It's not. May not be, but we have said already. Very well. Already listed as per the orders. No? Very well. Will be listed.
Top of the board. My lords.
Madam Mahalakshmi, after 5 8.
I listed. I said, don't ask for a moon. Don't ask for the moon.
My lords, great.
Let the date be first thereafter.
Yes, there is no point.
My lords, with my lords' permission, may I mention item 114 listed today, my lords. My lords, in this matter, the appellant has been released from the jail, my lords. My lords, I have been provided with certificate of...
Infructuous it is.
Please, my lords.
The appeal.
My lords, it was listed today.
File then.
File nikal dena.
Mansa.
The last time was said.
After completion of sentence.
My lords, nothing remains in the appeal, my lords. Has completed his sentence, my lords.
He can still challenge it. Stigma remains.
Since your lordship has said that but conviction remains, that is the reason. So he is the father.
Arising out of the judgment of conviction and sentence as directed. Right. As directed by the trial court, confirmed by the High Court for the charge under section so and so. The present appeal has been filed. Full stop. Counsel appearing for the respondent state submitted a certificate issued by the Deputy Superintendent, Central Jail, Mansa,
District Jail.
Deputy Superintendent, Central Jail.
District Jail.
Calika, signed by, issued by Superintendent District Jail, Mansa. As per the said certificate, accused after serving the sentence have been released on 5/9/24 from the jail. First off, in view of the above, as the sentence has already been served by the appellant, we dismiss this appeal.
Opposite of us.
This appeal has now rendered infectious, and accordingly it is dismissed.
Grateful.
As stated, as stated, this appeal has now rendered infectious. Get up. Yes, please.
So, my lord, your lordships have gone through the affidavits.
Affidavit you filed before the High Court.
Both
Now
affidavits.
you please further say what is your stand before this court.
Yes, my lord, my respectful submission.
Then we will go for your contention.
Yes. My lord, my respectful submission is that,
So what is your stand here before this court?
yes, my lord, my stand before this honorable court is that the NCT guidelines leave a discretion to every state that what TET they would provide for selection of primary teachers or other teachers wherever it is applicable in that state. It will be complete discretion of the state under the NCT guidelines themselves. Forget 23.2 for the time being, because that's not argued there. Let us now keep 23.2 aside. Let us stick to the NCT guidelines. NCT guidelines.
Clause 10.
Clause 10. Hence, I'll read that clause 10, my lord, in a moment. But your lordship, and secondly, my lord, this is the first submission. Secondly, expansion of zone of consideration.
जवाब देना.
Expansion of zone of
सुप्रीम कोर्ट में जवाब 1 to 5 का जवाब सुप्रीम कोर्ट.
Yes, my lord. Kindly come to my lord para 3 through para 6 onwards.
Yes.
Sub Roman 1, your lordship may skip, my lord. This is sub clause 2 at page 3 also, my lord, is the background. Kindly come to Roman 3. If your lordship just permit me to read Roman 3.
Yes.
By the letter of so and so, NCT framed guidelines from clause 10b of the guideline of NCT for conducting teacher, it appears that the state can consider CET examination qualification as the qualification for the to be appointed as state of Jharkhand. So that is permissible under the, so let's stick to this only for the time being for your lordship kind consideration. That NCT guideline, my lord, will flow from the RT and they are, my lord, to be followed by the states uniformly. That itself extends the discretion to the state government in what manner under, so our case, my lord, for this decision of permitting the CTAT candidates and, my lord, the other state candidate is permissible under clause 10 itself.
No, then what would be your contention as you were saying that if we see this, then this doesn't apply?
No, my lord, I am saying that let us assume there are two submissions, my lord. First submission, your lordship said, was never before the High Court, so I am keeping it aside. That 23(2) only talks of courses as well as training, which, my lord, TET would not be. TET is an eligibility test, so therefore it would not fall under that entire mechanism.
No, Mr. Maninder Singh, once you can't be appointed without having that certificate, you don't say it is a qualification, but it is a certificate. All right.
It's eligibility, yes, my lord.
Once you can't be appointed.
Yes, my lord.
So why it is not a qualification?
No, that's, supposing, my lord, I'm 17 years of age.
Right.
And eligibility is 18. So therefore, I'm not eligible.
Age is a different.
Yes, something more, something more. It is not a degree on which I can rely.
This is a qualification.
If your lordship may kindly permit me to read one line of the.
This is mentioned in the essential qualifications.
Therefore, I don't want to go into that for the time being, but
That's all right.
kindly see, my lord, for only moment in this counter affidavit where the TET rules are placed. Kindly just give me one moment, page 29. In this counter before your lordship, where the TET rules have been placed, we start at page 21. Kindly come to 29, rule 11. And this is not under any challenge because this was not the issue. I am only bringing it to your lordship kind notice. 29.
That's right. If you pass graduation,
Yes, my lord.
right? Can you say you should be given employment?
No, my lord.
No.
My lord, that's sort of.
It's kind of that thing only.
That is what.
This will not entitle you to appointment. You will be eligible for consideration. That's all.
I'm saying, but my lord, your lordship.
This is provided in the qualification clause.
I'm not, my lord, that is the position, my lord, which your lordships have seen. I'm only saying, my lord, if the words which have been used in the section 23(2), the entire emphasis is on the courses or training. I'm not.
Not your stand even before Supreme Court.
But
Not your stand even before Supreme Court. We can understand that you would have said something in Supreme Court.
Lord, I do not want to, my lord, but
No.
take your, no, my lord, ultimately, my lord,
No, this is not.
my lord, your lordship.
The intent of section 23 subclause 2 is very clear.
Yes, my lord.
It is of twofold.
Yes, my lord.
Where a state does not have a adequate institution offering courses or training in teachers education or teachers possessing minimum qualification as laid down under subsection 1
My lord, I'm not bothering.
are not available to sufficient members.
Lord, I'm not bothering your lordship. I'm saying that this is for the time being. Lord, clause 10, I'm relying.
Yes, that will
Come
be
to clause 10 now.
226.
226 of.
Yeah.
Come to clause 10.
Yeah, Lord,
So your first contention is primarily is not tenable.
Lord, I'm not raising it down, Lord. Your
All right. We'll take it as a not raising.
Lord, I'm not, because then I have to.
We'll take it as a not raising. You have said not raising.
Yes, Lord, 226.
Mr. Maninder Singh, you had taken us up to the Allahabad, basically going to Jharkhand, now back to
I
Delhi
have
again.
taken your lordship.
Back to Delhi only now.
Your lordship may kindly now come to 226, 22 is that, my lord, 11,
Yes.
February 11. And kindly come to, my lord, applicability at 226, clause 10.
So these are the guidelines issued by
The NCTE.
NCT. All right, come to 10.
And my lord, only for the, because I'm going to rely on two judgments of this honorable court which have dealt with the 9. So just make a note of clause 9. And then, my lord, the honorable court has laid down certain principles. I'll just read few paragraphs from two judgments.
All right.
Now kindly see 10. Applicability. TET conducted by the central government shall apply to all schools referred to in subclause 1 of clause A of section 2 of the RT Act, which are, my lord, schools run by the central government. So, my lord, therefore, central government schools, obviously the central government has provided its own TET, it will always be applicable. That is what the NCT also says. TET conducted by a state government, UT with legislature shall apply. So state is, my lord, has been put at par for this purposes with the UT which has a legislature like Pondicherry or Delhi. A school of the state government, and my lord, your lordship may just keep that in mind. There is word A and there is word D. In given circumstances, my lord, in a statute, we would have bothered your lordship. A means any or D means a particular. Just keep that in mind. I'm not.
So this was raised by
Yes,
Mr. Gopal.
so therefore just keep that in mind. I would say, my lord, if that is to be considered, then it is to the contrary. I'll show that how. That conducted by a state. Here, A would mean any. That's my respectful submission. In this provision, which is not a statute, I'm conscious of it, but since the argument is raised, A state would mean any, and would mean every. It is not the state who's conducting the exam. Kindly consider that, my lord, that's my humble, respectful submission. A would mean any. So, my lord, any state, if a TET conducted by any state or UT with legislature, this is the class. It is not restricted to what your lordship are considering Jharkhand.
All right.
What
Go ahead. Go ahead.
to Delhi.
Go ahead, Mr.
Now, kindly see further. A school, and then it is this A is again any.
Sometime for a teaching, it is very good that we will take your teaching.
Now, for me, for learning, Lord.
Sometimes this, always.
But we request you to
Nobody
take
said
it right.
such arguments are such arguments comes.
No,
So
Lord.
it's mongling the mind from this side to that side to this side. Huh?
We are only.
All right, please.
Assist your lordship, Lord, in any
No, all
case,
right, all right.
Lord, from this side, our responsibility is much higher. For the state to assist the
Please go on.
Now, my lord, A school would mean any school of the state government UT with the legislature. So it is referring to every school in that state with UT
Yes.
legislature and a local authority. Refer to in subclause 1 of my lord, that section 10 where lordship have found that the schools, my lord, definition of schools and appropriate government. My lord, your lordship can keep that with your lordship.
Definition clause.
Yes, my lord. In subclause 1 of section 2E, then a school referred to in subclause 2 of clause N of section so and so in that state duty, a school at 1 and 2 may also consider. Now this is may also mean my discretion
Yes.
and discretion of every state, including me. It is a vestige of a discretion. Let me assume, my lord, NCT is the final authority for 23(2) for its interpretation. I am assuming for the sake of argument. Then this leaves a discretion for every state. May consider. What is may consider? And my lord, the background and the foundation will bother your lordship in some other case is the federal structure for the subject of education. Primary education is always with the state. Kindly see, my lord, a school at 1 and 2 may also consider eligibility of a candidate who has obtained TET certificate awarded by another state UT with the legislature. This is first of all a discretion. At a lower pedestal, it is an enabling provision.
This is for other state or UT with legislature, not the central government.
I'm not, yes, that 1-2 is only this 1-2 here,
Yes.
just above. You're absolutely right.
You have made eligible the CTET.
Exactly. No, my lord, CET is
Correct.
for a TET of any other state. Kindly see, my lord, a school may also consider eligible who has obtained TET certificate awarded by another state
State,
of your
not
legislature.
center.
I'll
Number one.
I'll go further.
This proviso kind of a thing is only with clause B.
Lord, it is for clause B and 1 and 2 in B.
Yes, yes.
Your lordship
He
has
is
to.
talking about state only.
So this discretion is with me that is,
Only for state, not center.
yes, in addition to my TET, I can also consider.
Any other state.
This is left to
Fine.
me. Please see further. In case a state government UT with legislature decide not to conduct a TET, a school at 1 and 2 would also consider TET conducted by the central government. This again, my lord, first of all, my first submission. This is acknowledging and respecting the federal structure. That a state may take upon the state, you should not be having an allegation. Central government is imposing something which may be left to the state. That's first submission. Your lordship, just keep that at the back of your mind. Second,
Now let us understand on this. Suppose we take these words as it is and a plain reading of this.
yes, my lord.
This subsequent clause applies in case the state government undertaking with legislature
Sorry.
decide not to conduct a TET. Ever you taken this stand that we have decided not to conduct the TET?
No, my lord.
No.
On the contrary, affidavit says we conduct.
You are conducting.
We are upgrading.
So emphasizing this part
Yes, my lord.
and submitting that a school 1 and 2 in the state would consider TET education, emphasizing this part, or you have to first qualify or you first have removed the rigor of first.
That is
In any case.
better over that you are not conducting your own test.
No, not conducting. In any case, you decided to not to conduct. So you have not decided to not to conduct.
I am decided I will conduct.
Then this will not
Then
apply.
this will not apply.
Permit me.
That is,
I am-
yes, we are permitting you, Mr.
Now, my lord, kindly take my submission.
Yes.
The submission is this, my lord, that a state expanding a zone of consideration
सभी लोग जम
by
कर शेयर करें
taking, my
यहाँ
lord,
पर
if I may
बहुत
can make
जल्द
that
final
humble
फैसला
submission,
होने जा
because your
रहा है।
lordship put it to me while I was reading the affidavit, that I, as the Jharkhand state for JTET, I want to bring it at the standard of CTET. Right, my lord? Your lordships have laid down wherever a qualification is prescribed, you can always go for the qualification. Let me borrow that.
Not in all cases.
It's not a question of higher qualification. It's not a question of higher qualification.
No, my lord,
It's a question, just please, don't put this
higher standard, my lord.
humble request. Don't put this argument on higher qualification. Because TET and
It's not a
JTET,
qualification. No, I am with
you yourself is saying is not a qualification. One thing, and JTET, CTET and JTET are
Same.
all similar.
Yes, my lord. Now, my lord, I say that.
So you want to
All
append.
right, the stand, let me put it
Yes.
to the standard, my lord. The standard is higher and let me, my lord,
And that standard you want to put in the first affidavit, but in the second affidavit, you don't want to do that. The second affidavit, you want to say that whatever we are doing is right.
my lord, if that's not the position.
No,
my lord,
it is there on your stand.
my lord, so
We
therefore,
cannot go more than this.
therefore, my lord,
Mr. Manikar, probably nothing is there in this argument.
no, all right, my lord, I am going.
Nothing is there in this argument. Please.
No, my lord, I am only saying
Yes.
that the
You are saying that the discretion is vested with you under this clause, and in exercise of that discretion, if you made a concession pro advocate general before the High Court, and if it is regarded by way of legislature subsequently, and examination have been conducted accordingly, then cannot be put into hold by this court.
And
This is all
with
contained.
one more,
Full and final.
I'm deeply
Anything else?
One more submission, my lord, that a expansion of the consideration zone, expansion, any attempt,
Is permissible.
my lord, it is justified and it is, this is within the scheme of the constitution to give opportunity.
Oh,
My lord, my lord,
along with that, there is another preemption. What your rules says for recruitment. These guidelines will not take away the rules. The
JTET,
statutory rules framed by you for recruitment of teachers.
JTET,
309.
yes, my lord.
So how those will be taken care of
Rules are amended.
later on? For that, they have a different argument.
I'm coming to that argument. also.
Yes.
Yes, so therefore, the rules before the last date of the application,
All right, that argument is a separate argument.
I'm coming to that, I'm.
But this will not take over everything till such time the rules to the contrary are there.
No, but therefore, my submission is this. My rules for this election also provide CTET also to be permissible.
After amendment.
From January 24,
Yes.
29 January 24
Yes.
after the amendment.
Yes.
Last
One thing.
day, I'm sorry.
After this judgment, in reference to the judgment, rule have been amended. And the judgment is under challenge for us.
Lord, I will show your lordships a similar situation where your lordships have permitted that with reference.
All right,
No, my lord, with,
all right.
with reference.
So we have to be very clear and specific on the point
My lord, your
that how
lordship.
far the judgment is correct.
Yeah, Lord, let
If
me.
the judgment is correct, then there may be a possibility your argument may be acceptable. But if the judgment we find not correct, then
I'm coming back to that. So, my lord, my first submission, your lordship saw the July order. The July order of 2023, which your lordships have seen at page 52, my lord, in the counter affidavit, the interim order, this only gives an observation for suggestion for the state to consider. And that consideration is that there are people who are we seated, they are already available, they are now coming before us that we should be permitted. Why should we be blocked in sitting in the entrance examination for this recruitment? You please consider it. This has been considered, my lord, and at the time when the matter is finally argued on the file, whatever decision they have taken, the learned advocate general is instructed to make that submission. The judgment only record the statement made on behalf of the state for its policy decision. That policy decision, my lord, in my respectful submission, even if it would have not taken, it had now taken the character of an amendment.
So Maninder Singh, I'm sorry to say, any statement made by the Advocate General cannot be said to be a policy decision of the state.
Statement.
If it is being just, please, no.
But I showed you.
Sorry. If it is being said by the Advocate General, now the state government has taken a policy decision, and by that policy decision, we are going to that. We can understand. And the state government, if the Advocate Generals gave a consent, no, please, we'll do it, and that cannot be said to be a policy decision. Sorry to object for it.
These are the
No, Mr. Maninder Singh, we cannot accept like this. After your stand taken here in this case, like this, an Advocate General gives a concession. It's a concession only. Cannot be said to be a policy decision. You read the words. Finally, read the words in the judgment.
Looking at.
Oh, sorry, Mr. Maninder Singh. No, sorry.
My lord,
Please, we can understand whatever the words. You kindly see the wordings of the judgment.
Yes, my lord.
Kindly see the wordings of the judgment.
There are 600 at page 11. However, in course of hearing these today, the Advocate General appearing for the state would submit that he has received oral instruction that the state is willing to relax the criteria.
Third area.
Now this is a policy decision.
No.
Well, that's
This
why.
cannot be said.
My lord, if the state considers it, Lord, state considers it, and Lord, state considers it, inform the learned Advocate General that you please inform the Honorable Court that a
Let
disorder.
him say that's a policy decision has been taken by the state government, and we are doing this. That is say.
The state is willing to relax the criteria for eligibility as far as the candidate having teeth at examination certificate with a stipulation that in future they would require.
Come to your argument, please.
So that's my lord, that's my respectful submission. This policy decision then gets
No.
Lord,
You can take a policy decision contrary to the rules.
Lord, if the rules have to be amended, the policy decision is taken always.
Framing of rules is matter of policy.
Lord, the rules.
Policy have been framed, rules have been framed in the region of 9.
Lord, the amendment. Yes, Lord, the
We
amendment.
cannot accept. Otherwise, every day the state can do. The sovereignty and sovereign powers of the states are not prescribed
Lord, that's what I'm.
for this purpose.
Lord, that's why I'm.
Sorry.
And just see whether there is any power of
Go ahead.
relaxation given in the statutory rules for recruitment.
Lord, if supposing, my lord, if I go by the clause 10 of the guidelines,
Guidelines will not supersede the rules.
I'm not saying, my lord, I'm saying my rules amendment is to come in guideline with the NCT and take the C-stat in.
That's all.
My only respectful
So like
submission.
that is a separate argument. We'll consider whether for after amendment your cutoff date will be
Yes.
seen to be a good action.
So my first respectful submission go at this stage, my lord, only at the cost
And
of this.
therefore, for this intent, we have put that Bihar case separately. Understanding this,
Challenge to the virus.
Yes, my
we have
lord.
said we will hear that.
Absolutely right, absolutely right. So, my lord, therefore,
In that case, the situation would be different.
my lord, therefore,
Because in that case, we have to look into the regions, statement of regions and objects. What was the region in that?
yes, my lord.
That is entirely a different thing when we are examining the case of the varies of. Anyway,
No,
you
therefore-
carry on with your
Proceed now.
argument. Yeah, proceed.
I will, my lord, I would seek a lordship permission when I am arguing the next point, that you can't change.
Come on the next point. We have understand your point. We have already clarified you. We have understand your point.
Yes, my lord.
You please come on the next point.
Now, my
Please,
next,
Mr. Maninder.
yes, my lord. My next submission is, my lord,
Yes, please.
that the amendment having been made in January 24. Now, my lord, here,
That amendment.
29 January.
yes, my lord, that has been
Which
placed
page?
on record.
This
The
is
counter
The counter affidavit.
counter affidavit.
Yes, my lord, page 60.
60.
Yeah,
Page 60.
29 January.
Twenty-ninth of January 24. Under powers conferred to proviso to Article 309 of the Constitution, the Governor of Jharkhand hereby makes the following amendments in the Assistant Teacher Cadre Appointment so-and-so rules of 2023, which is, my lord, originally 22 and 23, but also amended. from following amendments are there. The rule made under the clause A. The rule shall be called so and so amendment rules of 2024.
Right.
And then, my lord, for the present purposes,